evening where we are. This is Dan Real. I'm with Fraudclosure 101, and hopefully you've had a chance to look at the rest of the channel, and you've seen, hopefully, our introductory video. If you haven't seen it, please watch that first and foremost before you visit this one. This segment deals with discovery tools. Now, a lot of people have that question. They've heard the term, they don't quite know what it means, especially if they're a homeowner and they've never been involved in litigation before. They're like, what is discovery? Discovery is a broad set of different procedures, techniques, and forms of requests and ways to explore what it is the other side is actually dealing with. Now, say for example, you're not in a courtroom. You're dealing with two opposing armies. Now, what do armies do? They typically have these people that do what's called reconnaissance. Say there's another army on the other side of the hill. You want to find out what they're fighting with, what kind of firepower they have, how far it can reach, and what they're playing with. And the reason we have discovery in the adversarial legal process is because, unlike war, we have this general rule of thumb in courts where you can't just jump up at the last minute and yell, surprise, especially if the other party has asked for evidence or documents or about different facts that may or may not be established. Now, we're going to briefly cover discovery tools. Obviously this is a big subset of law, and there's a lot of legal resources out there. I know the Connecticut court system has this thing called Pathfinders. You can go to jud.ct.gov. You can look them all up. It's very valuable, and this is pretty much true generally regardless of what other jurisdiction in the United States you're talking about. So if you want specifics on the different rules, you're going to have to consult the different rules in the jurisdiction you happen to be located in. Now, with that said, we have first one, requests for admissions. Now, requests for admissions are very simple. They're a statement that the opposing party can admit, deny, or object to on whatever grounds. I mean, discovery objections are a different discussion, but basically, we're just doing this to familiarize you with the different possibilities for discovery that are out there. Now, requests for admissions, they'll be numbered, and you'll have to provide a space for the other side to respond. Example, request for admission. Bob is an acrobat. Now, I highly doubt you're going to be running into acrobats and all this stuff and the purposes of foreclosure, but I'm just writing this as an example. It's just an example, fictitious admission. Now, Bob on the other side, he can say admitted, he can say denied, or he can object on whatever grounds he wants. It's pretty simple. And the reason we use requests for admissions is we want to rule out which different facts we're going to have to try and establish as the case gets going down the line. Now, for example, within the context of foreclosures, you might have a request for admissions that says the plaintiff is not the holder of the note. Now, obviously, that's quite relevant, because if they're not the holder of the note, there's a big problem. Now, interrogatories. These are questions. Our example question here, how old is Bob? Bob, on the other side, might respond if it happens to be relevant. It usually would be, or kind of, wouldn't be a big deal to answer depending on the case. But Bob will say 58. Bob is 58 years old. No problem with that. Interrogatories have to be answered under oath. That's very important. Which is why, within my profession, when I'm helping lawyers prepare discovery requests, we have space on the bottom of the set of the request that has a place where, a notary or an attorney, can take an oath as a commissioner of the Superior Court. And we'll usually ask questions that go with the interrogatories, like who prepared the interrogatories, who assisted with the interrogatories, where are the records. And within the context of foreclosure, the thing you have to remember is foreclosures, especially securitized foreclosures, are business records cases. So in other words, you have to establish chain of custody, you have to find out where these records are, and you really have to target your inquiries very clearly and precisely to find out what is relevant, what is not relevant, and if you miss something, where you might be able to track back and find it. Third tool, very useful, request for production. Our example request for production here. Please produce Bob's receipts from Pizza Hut for fiscal year 2015. Again, highly unlikely that you'll ever see a question like that, but it's just an example question in that format for a request for production. In the case of a lender in a foreclosure, you might say first request for production. Please produce all records of payments and invoices and stuff like that. It's not terribly burdensome, especially if they're trying to foreclose you and they're saying, hey, you didn't pay. Well, please produce an accurate accounting ledger of my payments or non-payments as you claim the case may be. Okay, depositions. A lot of people have heard this term. We use depositions because it's a lot easier and perhaps more convenient to get testimony outside of a hearing in court. Like it or not, the fundamental reality of courts is they're very busy, they have a lot of cases, we want to get things moving, we want to get evidence, so what we'll do is we'll serve what's called a notice of deposition on the side that we're looking to depose or the witness we're looking to depose. It's usually an individual, but in some cases you have what's called a corporate representative deposition, where you basically serve a corporation, usually a bank within the context of foreclosure, with a notice that we're looking to depose a representative of, say, Bank of America, Wells Fargo, and we want that person to come and testify as to what they know. And the great thing about a corporate rep deposition is the plaintiff, the foreclosing plaintiff in this case, would usually have to find a witness, find somebody, prepare them, and they would have to study the material, and then they would have to come testify based on what they know. And if they do it incorrectly, well, they're stuck with those answers. And that can be very helpful. It kind of gets into strategy at that point, but I'm just throwing out, how things can typically go. That, if you're really looking to uncover fraud, depositions are very useful. The thing you'd have to consider from your standpoint, though, is do you have money to pay the court reporter? Do you have money to pay witness fees? Do you have money to pay your attorney to do depositions? It's a very powerful tool, but it can be a very expensive one. On that note, as far as depositions go, we have subpoenas and we have subpoena duces tecum. What's the difference between the two? A regular subpoena is just you come testify at this point, tell what you know. A subpoena duces tecum is basically a subpoena that says bring these objects or documents with you. So in other words, if you were to subpoena, I don't know, hypothetically, the vice president of servicing at, LPS, you would say, okay, please bring your employee manual with you. That may be relevant, it may not be relevant. I can't give legal advice or specifically comment on the specifics of the case, but the bottom line is, that tool is there. Now, bearing all of these tools in mind, one thing that I absolutely cannot stress enough is you should avoid discovery abuse. Do not ask questions for the sake of asking questions. Do not throw requests for admissions or interrogatories or requests for production for the purpose of slowing them down or piling it on. Be targeted, be precise. And the reason I say that is because if you fail to do this, and you fail to do this at the right time, you might find yourself faced with a motion for a protective order. Now, a motion for a protective order is basically a motion brought by the opposing side that doesn't want to answer your discovery, and they're basically making the grounds to the court saying, hey, I shouldn't have to answer this because this is abusive, this is burdensome, this is oppressive, this isn't likely to lead to any, specific evidence. And unfortunately, a lot of people, they do jump the gun, they do go hog wild, and they find themselves in a situation where not only do their inquiries that a lot of them have merit not get answered, but because they went hog wild and overboard, now they have no discovery. And in a business records case, that's make it or break it. So, as always, consult an attorney, and this is definitely, these are all different tools you should bring up to your attorney. Ask your attorney whether he or she does these things, and, see if it would be applicable in your case, and Any questions, comments, send an email, headlinecopy@gmail.com. If there's something you think we left out of this video, let us know. We'll put it up, and hope to hear from you soon.